Welcome to Tony at 12. I'm Tony LeBlanc, and today I'm in conversation with Marek Oleksyn, a leading global lawyer on the subject of artificial intelligence. And today we're going truly international as Marek is based in Warsaw, Poland. Marek, good to see you.
Good to see you, Tony. Thank you very much. Thank you for having me, and welcome to everyone.
My pleasure. Now, the subject, artificial intelligence, which we call AI. And I've got down a little point here, the future looms. How do you see that?
Absolutely, that's a great starting point. And indeed, we can say we are happy to witness a historical change taking place before our eyes as regards development of artificial intelligence. I would say that we are right now in a key moment of putting out and setting out some regulations concerning the ethical and correct, let's call it like this, use of artificial intelligence, not only nationally, but also in the regional and global perspective. So it seems that indeed we are facing very, very interesting times, and those faster and faster changes in this area, they touch not only to lots of different industry sectors like transport, healthcare, marketing, for example, but also they touch upon everyday life of each citizen. So yeah, very interesting times indeed.
It's a new branch of law, and it's showing how the legal system continues to evolve. You know, if somebody comes up with an idea, then possibly one has to take forward. But this time round, it seems to me that you're in front of the game.
I'm trying to keep the pace, yes, and indeed there is lots going on as regards regulations touching artificial intelligence development, and we are also lucky to observe the developments from the European perspective, where we think and we can see it based on the true actions taken, that indeed Europe tries to be, let's call it, a trailblazer for development of regulations covering artificial intelligence. A great example is the legislative initiatives within the European Union and the most recent EU Commission proposal for artificial intelligence published on April 2021. But this is not the only legal paper which pertains to artificial intelligence, as we should also expect European Union rules to address liability issues related to new technologies, but also some revision of sectoral safety regulations and legislations where AI would be the key point, like, for example, machinery regulation or general product safety directive.
We've sort of got AI around already, haven't we, in terms of the fact that you have automated telephone answering systems and various things like that, which I suppose are a fair, what looking towards the future will be viewed as a fairly crude system of artificial intelligence. But so far, nothing's really been done about that. When did you actually see the opportunity as a lawyer to take this forward, Marek?
Yeah, that's a good question as regards the timeline between the development of artificial intelligence and the moment in which the AI solutions or AI algorithms indeed started to have true impact on economy and on human lives. As regards the development of AI as such, that's the phenomenon of the last several decades. But its real impact on the economy, on the people's lives, is, I would say, primarily the last 7 up to 10 years. And this was more or less the moment when this process began to be seen as a harbinger of actual change. But as regards the regulatory or the legal aspects of AI and its application to reality, I would say that's a matter of the past 3 or 5 years when it truly started to matter. And just to give you one example, as regards the expenditures which the European Commission plans to invest through Digital Europe or Digital Horizon programs, that would be €1 billion per year in artificial intelligence. So it shows how this snowball is getting bigger and cannot be stopped.
Is that shared based on population around the EU?
That's basically the general approach of the European Commission, how they would like to invest in development of safe and ethical artificial intelligence tools. And indeed, EU Commission also mentioned that they would like to invite private sector and businesses to invest also in artificial intelligence based on country by country basis. And indeed, this would lots would depend on particular countries and also its population, of course.
Yeah. I mean, we've acknowledged the fact that obviously regulation's important on this, but equally important is the question of consistency, isn't it?
Absolutely.
And that's not just Europe; that's looking at it globally.
That's a very good observation, Tony, and I fully agree with this. And that's one of the key challenges which not only Europe but also other regional markets are facing right now. Is I would compare it somehow to the situation with pollution, with global warming, which has by its nature a global impact. Same for artificial intelligence. And regardless of what we do on regional level, like the European one, for example, it is indeed critical that the same ethical standards and the same general principles and rules are applied globally, at least by the key markets, not only the European one. So indeed, it's crucial to have the same level of principles applied globally.
And presumably you're trying to aim to a situation where management is going to be semi-universal, and therefore regulatory costs should be reduced as a result of that. Yes.
Yes, exactly. That's also one of the observations, but also one of the goals. Namely, we should indeed expect further drop down of regulatory costs and management costs as a result of application of AI algorithms. Absolutely.
So once you've gone through the formation of the legislation, the EU will presumably then put it through the European Parliament firstly, and then through the Commission to actually effectively make it law for the whole of the 27 countries. Is that correct?
Yes, that's correct. And perhaps maybe just a few words of the background of the EU's approach on this is that European Union was very active from the very beginning in terms of creating the right legal environment for the development of artificial intelligence. And the draft EU Commission proposal for artificial intelligence of April 2021 mentioned earlier, it was followed by some earlier initiatives from the EU, like, for example, April 2018 communication from the Commission on Artificial Intelligence for Europe, or the February 2020 Commission white paper on AI, or, for example, the initiative to establish a high-level expert group that published guidelines on trustworthy AI. But coming back to your question, indeed, we have right now a draft proposal of AI regulation on the table, and it should, let's say, proceed with the full path of legislation process. It is planned to enter into force presumably half next year, and the obligations arising from this regulation will start to bind, at least as of now, somewhere in 2024. So right now we should expect some vivid discussion about the draft regulation proposal and some comments from the stakeholders.
Does it require each of the 27 countries to accept it? Can a veto be applied at all, or do you think it will just go through on the nod?
Mm-hmm. Yeah, so I would say both scenarios, because as regards the AI as such, it will be adopted through the regulation, which will be directly applicable to all EU member states. And it was a conscious decision made by the European Union to have this implemented through regulation and not a directive, but also there should be some auxiliary actions like sectoral changes in the relevant laws where they can be done through directives and then implemented in each EU countries. And by that, each country perhaps may have some flexibility as regards the scope of harmonization.
So to that extent, you've currently got 27 separate legal systems operating within the EU, representing the member countries. In the event of court procedure enforcing the legislation, would that be done at a local, i.e. country level, or through the European Court of Justice?
Okay, as regards the enforcement, I think that so far the judiciary system will be the same as regards dealing with AI issues and aspects, meaning that the Court of Justice of the European Union will still be competent to decide within the scope of its expertise and competences. For example, in cases against member states, against the authorities, but also as regards judicial questions posed by relevant courts, for example, by national courts. And on the other hand, as regards the very cases which involve artificial intelligence, they will be dealt with by national courts, at least as of now, of course.
Okay, so that sort of covers the legislation side. Now we come to the nitty gritty. And that is this question of patents or patents, and the creator of the algorithm that actually creates the thing, man or machine, Marek?
Yeah, that's a good question, man or machine. I would right now I would call it that it's 1-0 for man. So as regards the so far attempts to have a machine or an AI algorithm be indicated in the patent application as the creator, it was unsuccessful. As of now, the game is still pending because the relevant appeals have been filed. So we are very curious to hear about the outcome of the very loud case of Dabus inventions, which were filed both before the EU European Patent Office, but also before the UK Patent Office and before the USPTO. So we should expect some final outcomes perhaps still this year or early next year. But so far the decisions were that a machine cannot be indicated as the inventor or as the author of an invention.
But if we hit 1984, the book, sooner or later, the artificial intelligence, the machines will be taking us over, or potentially they'll be able to create themselves. So this is where it all gets a little bit into science fiction, I suppose, doesn't it?
Actually, when you mentioned that, I was just thinking that perhaps it will not happen, and let's keep our fingers crossed for that. But let's hope it will not be the way that machines will discuss in a way like we do right now, whether to give us capacity of being inventor or not. but as of now, yeah, humans are the ones to invent.
One thing I did note from that webinar you did with Michael Manelli was this question of legal personality. Now, a human being can have legal personality. A corporate body, a company can have legal personality. But where do we see artificial intelligence fitting into that one? You're going to have to make provision, are you, in the legislation to cover that?
Right. So the topic is still open. And so far, the approach, at least on the European level, was that for various reasons, pertaining mostly to liability issues as a result of concerning damage caused by machine driven by artificial intelligence, for example, the answer is there is no need there is no goal to create some legal personality vested with artificial intelligence as such. But there are also lots of arguments against this approach and against this position. And apparently, while the legislation and regulations will evolve and will get more, let's say, more perfect as regards artificial intelligence, it may happen that we'll get back to this discussion pretty shortly.
Yeah, because following on from that, if you did create a legal personality for an item of artificial intelligence, how do you wind it up? And by that, I don't mean it's clockwork. I mean when it comes to the end of its business life.
Yeah, absolutely. And thinking about your question, I was thinking, what would happen if you get an upgraded or a second version of the same algorithm? Would it be the same legal entity, or rather, there would be a multiplication of a legal entity? And indeed, where such personality would cease to exist. And I think that there is no answer to that so far, as we still have algorithms and software created back in the 80s, for example, or 70s.
Yeah,
so,
but what you say is quite true, isn't it? If you take mobile phones, for example, we're up to 5G, having sort of gone through 2, 3, 4G. So, you know, it is a question, isn't it, that as one goes along and technology develops, then you've got to sort of view what could be happening in 25, 30 years time as part of it, due to the fact that you're going to find that various items of technology are going to be updated, upgraded, and possibly have a different personality.
Yes, indeed. The times we live in are so very interesting, because there is no easy answer to any question. And indeed, it may happen that in like 3 or 5 years, the concept and the approach to legal personality will change. And for example, if we come up with a situation or a proposal that there is some security found for liability caused by robots, for example, vested with artificial intelligence, or there is some register effective of artificial intelligence whereby claims can be effectively sought against such artificial intelligence algorithm or its owner, then perhaps our discussion may need to be slightly adjusted as regards vesting such personality.
Inevitably, we get into the question of copyrights. And I believe, and you know more about this than I do, there was a case of ING reproducing a 3D version of a Rembrandt. And the question was, who owns the copyright?
Exactly. And that question was actually, and perhaps luckily, unanswered, because fortunately there was no dispute whatsoever behind that. But of course, lawyers started digging around that, and they started to thinking about who should own copyright in this piece of work, and whether this piece of work as such should benefit to be copyrighted and enjoy copyright protection at all. And the answer behind that, or let's say predominant answer for this question, was that indeed, this painting created by AI algorithm, which was developed throughout a couple of years by lots of specialists and AI experts and historians, that this piece should be considered copyrightable work. But on the other hand, given current regulatory system in different countries, those who truly contributed in development of this final piece of work should be considered co-authors rather than AI algorithm as such, even though those persons did not know how the final painting would look like. That was very interesting. And even though the answer to that would be co-authors, or perhaps if this work was the so-called work made for hire by ING, for example.
At the time they did it, who actually owned the copyright of the actual painting?
Of the actual painting. So perhaps the most commonly repeated approach is that this should belong to ING or the organizations which contributed and produced the project and hired personnel who was involved in preparing the AI algorithm and the Rembrandt skills as such, as they would have sufficient agreements with the persons involved in the project, or in case it was a concept of a work made for hire, where their creative contribution was, let's say, shifted or transferred to the companies which organize the event and the painting.
But generally speaking, copyright is owned by the current owner of the item. If the artist, in the case of Rembrandt, hasn't been around for a while. So if you buy a painting, you effectively own the copyright.
If you buy the painting, if you buy the painting, you own the carrier of the copyright, like let's say the very painting. But on the other hand, the copyrights would be vested or would be shifted to co-authors of the painting, and in our case, co-authors of respective AI algorithm that created the painting. Yeah. Mm-hmm.
We've got another legal case that I'd like your comments on, and that was in the Singapore Court of Appeal, Global Yellow Pages versus Pro Media. Now, what was that all about?
Yeah, it was a dispute behind using the Yellow Pages phone books, and one of the considerations made by the Singapore court in that case was to check the copyrightability of compilation of the plaintiff's works, which was made with the use of AI algorithm, and the outcome of this piece of the matter was that this does not qualify as copyrightable work or enjoying copyright protection. So okay. Yeah, it was interesting because it was one of the very rare cases where copyright with respect to AI was examined by courts. We should expect more cases shortly, but so far.
Keep going, Marek. We seem to have lost you, frozen up a little bit there, but hopefully, yes, you're back. I think now. You just did a quick freeze for me. Looking at the Singapore Court of Appeal, would that become a precedent worldwide, or is it restricted to the country in which has the hearing? Just wondering why they went to Singapore with it.
Yeah, the reason behind that is that, as mentioned, there were not too many cases touching upon AI in creativity. I would say that this judgment, although it is quite often quoted, I wouldn't say that this may trigger any kind of precedent, especially given that it was issued on a very concrete case background, and it touched upon a very specific type of copyrightable work and a compilation of phone books. But it may, in some jurisdictions, show some insights and general overview on what should be considered copyrightable or not in terms of works being done with the aid or with the use of artificial intelligence. But I think that dependent on each jurisdiction, which we can expect also different outcomes.
Something that's probably going to affect all of us fairly shortly is this question of autonomous vehicles. Legal responsibility, the creator, the manufacturer, or the owner driver?
Yeah, that's another...
You've got three to choose from.
Is there a fourth answer to choose all of them? Because yeah, the subject is also again still open, so that's why the question is very good, because we are still facing challenges as regards drafting clear and precise rules and regimes of liability for damages caused by autonomous vehicles. And this is one of the initiatives mentioned earlier that we should expect from the EU as regards changes in product safety directive to address this issue as well. And also we can expect changes in sectoral legislation applying to different types, for example, medical devices, toys, and so on, where artificial intelligence would be used. But generally, so far, the manufacturer bears the liability. But on the other hand, given the definition of defect in the product and the damage caused as a result of this defect, and the causal link between them, it may trigger lots of unclarity as regards damage, which resulted in some kind of malfunction of artificial intelligence algorithm. And that is why some more clear rules as regards autonomous vehicles should be implemented, where those doubts would be, let's say, cast away.
This all reminds me of a case in the United States many years ago, where a lady was driving one of those big Winnebago campers. She put it on cruise control and then went to the back of the vehicle to make a cup of tea. Needless to say, it crashed. And I think they tried it on with the manufacturer, that it was the manufacturer's fault for saying, for not putting a sign, please stay at the wheel all the time.
Yeah, I've heard about this case, and honestly, I do not know what was the final outcome behind that.
No.
Yeah, there was no, but indeed, and there was no clear information that in such case, when you have a turn on the road, then this may not work so well.
But Marek, you just can't believe anyone would be that stupid, can you? Or can you?
No, and indeed, and I think that should be also one of the legislative efforts from all the relevant regulatory bodies, just to make it clear that this liability for artificial intelligence may not be, let's say, very generally speaking, of absolute character. Right now, it follows from this draft proposal that it's a risk-based liability, depending on the level of threat caused by artificial intelligence. But at the very end, of course, there's finally a human being behind that, and it does not absolve from being conscious and thinking about the possible consequences of using any kind of device.
Okay, looking at the future, do you think possibly there should be some sort of a world court to deal with these sort of claims? You know, well, I mean, obviously you don't want to sort of put in crime, you know, sort of Hague type situation. But as we're all sort of kicking off at the same time on this, then surely there could be a valid point in terms of saying, well, you know, it's a global situation, therefore we need a global court to deal with it.
Mm-hmm. That's a very good question, and I would say that although I haven't heard about such plans as of now, I think that as we have just discussed, the challenges are of global nature and of global character. So the general principles and the general rules of application of artificial intelligence should be the same throughout the whole world. And from this perspective, it may be indeed a very good idea to think about, if not a court perhaps, then at least some kind of council where those relevant regional or national legislation could be assessed and examined, whether they, for example, comply with some very general global rules of ethics of application of artificial intelligence, or also the general rules of liability, regardless of national nuances of liability. So indeed, it may happen that we'll face creation of such a court or such a body, which would perhaps not decide on a case-by-case basis of potential liability, but more generally, they would say whether this piece of legislation or this piece of policy is compliant with some more global rules concerning applicability of artificial intelligence.
A global level playing field.
Something like that, exactly.
My last question to you, Marek, and that was a bit of tongue-in-cheek here. Will the judiciary eventually become a machine?
Yeah, that's how to answer that. We cannot expect anything. The reality is changing so rapidly that perhaps right now considering a nice science fiction piece of discussion. But on the other hand, it changes so fast, and the AI tools help so much also the lawyers in getting into the correct assessment, or perhaps issuing the correct judgment, taking into account all the relevant facts of the case, that I would say that this human gaze and this human touch is absolutely critical and crucial when issuing a judgment in each particular case. So I would say that humans should not, or perhaps cannot be substituted with artificial intelligence. But on the other hand, we should expect more and more tools for the judges to come, which would allow them to act more quickly and help them in doing their work. So perhaps that would be the right direction.
A little bit more consistency, perhaps.
Exactly. Exactly.
Marek, Marek, it's been an absolute privilege and pleasure to talk to you. Really enjoyed it. So thank you so much for coming on. And I'm sure my viewers are going to enjoy it. And I'll be putting it out on Friday. So I'll send you the link. Thank you so much.
Thank you. Thank you very much, Tony. It was a great pleasure to be your guest and to discuss those interesting topics. And it was a great experience. Thank you very much.